So they're going to censor stuff with me?
All right, we are reconvening now from executive session. Notice this meeting was posted in the time and manner required, and there is a presence of a quorum tonight, and there I am. All right, we have one item on the agenda, and that is a presentation by our desegregation attorneys. Didn't know if you were talking to me or not. Okay, so Dr. Crawford, do you have you want to say a few words about this?
Sure. Tonight we have Marcos G. Ronquillo from the board's deployed desegregation order attorney, and he's going to be here tonight to provide I guess an update of what the process is and the potential of the district to go forward with unitary status. So we're invited to the podium at this time, Mr. Ronquillo.
Thank you, Mr. Chairman. Can everybody hear me okay? Is this mic working?
Yep.
Okay. All right, Mr. Chairman and Mr. Superintendent and members of the board, my name is Marcos Ronquillo. I'm one of three lawyers, Jose Gonzalez and Teresa Snelson of the Friedman Feiger firm, and we were retained to basically take a look at the status of the desegregation case with respect to the Tyler Independent School District. To obtain unitary status, TISD must prove that it has done basically two things: complied in good faith with desegregation orders for a reasonable period of time, and eliminated the vestiges of prior discrimination to the extent practicable. The second is that a declaration of unitary status signals the beginning of the end of federal judicial supervision over TISD's operations. School boards that operate state-compelled dual system schools have the affirmative duty to convert to a unitary system in which racial discrimination is eliminated root and branch. Unitary status is achieved when a school district is devoid of racial discrimination with regard to certain areas: faculty, staff, student assignment, facilities, transportation, and extracurricular activities. In reviewing the records with respect to the TISD, we have noted that there has been compliance with court orders for a reasonable period of time. First and foremost, the court entered the original desegregation order July 27, 1970, and there were subsequently 15 modified orders in the litigation. TISD has operated under the desegregation orders for at least 45 years. TISD has complied with each of those orders. Since 2001 to 2013, the court has approved the actions requested by TISD as being in the best interest of students. DOJ, the Department of Justice, conducted a review in 2012 and found that the school district complied in the areas of facilities and extracurricular activities, and basically said that the school system was unitary as to those two categories that are labeled the green factors. Since 1972, the school district has had no history of judicial enforcement or DOJ enforcement actions of the desegregation orders. Let's talk a little about the green factors. All the courts, going down from the Supreme Court to the Fifth Circuit, have identified what we call in the green case 6 green factors. The first being faculty, second being staff, student assignments, facilities, transportation, and extracurricular activities. It is our opinion that the school district, in its 45-year history of the desegregation case, has complied and has operated a unitary school system with respect to these factors. Let's talk first about faculty and staff assignments. The racial composition of faculty and staff within a school district's schools must be substantially the same as the racial composition of faculty and staff throughout the district. The racial composition of the principals, teachers, teacher aides, and other staff who work directly with children at a school cannot be such that it indicates that that school is intended for African American students or white students. Here's a slide based on our review that basically shows the growth in the number of African American teachers from '69 to 2015. As a side note, I do want to note that as compared to sister school districts throughout the state, Tyler compares very, very favorable to school districts throughout the state, more importantly, school districts that have complied with desegregation orders, and just as importantly, school districts that have been deemed unitary by the federal courts. Here's a slide that basically shows in blue all the years of compliance under a case law concept called the singleton ratio. And the singleton ratio just stands for a ratio where the student population, the faculty population of a given school is within 15 or 20% of a deviation of the overall population of the school district in that particular school year. You'll see in blue the number of years of compliance by the Tyler School District for each campus. You'll see in green a 20% deviation, which has been accepted by the Fifth Circuit as compliant and eligible for unitary status. The red marks where you've gone above and beyond a 20% deviation. Here we show consecutive year school compliance history at 15% deviation. And as you can see, 10 years into the litigation, all your campuses met a green factor with respect to faculty assignment, and that you were working very hard and you had achieved unitary status. With respect to student assignment, the Tyler School District has eliminated all one-race schools that the court found in 1972. The school district has eliminated all racially identifiable schools. The school district has eliminated racially imbalanced high schools, middle schools, and elementary schools. The school district has eliminated overlapping attendance zones, has undergone district-wide dramatic demographic shifts in racial composition. The school district has implemented magnet programs at Moore Middle School and Jones Elementary, Bell Academy, Caldwell Arts Academy as well. And student transfers account for less than 3% of students and have not resulted in recurrence of a dual school system. With respect to facilities, school district has passed 6 bond programs from 75 to 2013, over $450 million. New construction and renovation of middle schools and elementary schools and facilities have occurred. We have constructed a new career and technology center. We've opened new schools due to overcrowding with court approval. And we have closed some schools per court orders and court approval. With respect to transportation, the school district has eliminated 1970 segregated bus routes identified by the court, and the bus routes in 2015 serve all eligible students on the route. There are no circuitous or gerrymandered routes. With respect to extracurricular activities, i.e. athletics, student academic and non-academic organizations, the school district has achieved unitary status, no longer operates a dual school system, and more importantly, the Department of Justice in their 2012 review concurred and agreed that in this area, school district was unitary. There are other additional factors courts can consider, and one is the quality of education. And this additional factor can be considered by the court in determining whether a school district should be deemed unitary. And a court evaluates basically 2 things. Racial disparity exists in the provision of resources, and 2, equal educational opportunity is provided to minority students. As a side note, given the other school districts that we have represented in the past, I must say that the biggest challenge to us was trying to put on a piece of paper and document all of the good things that the school district has done to close the student achievement gap, to ensure that every student has an access to an equal educational opportunity, and that there is a concerted effort year by year by the board, by the superintendent, committed to quality education for students. And we take a look at the various ratings, all the various sources. TISD compares not just favorably, but most favorably with school districts of your size, your peers in the area, and more importantly, your other school districts throughout the state. Our dilemma will be not being able to put everything down that speaks to the provision of equal educational opportunity here in Tyler. Documents that we reviewed as part of the legal analysis, we've analyzed and archived records and court filings. We go way back to the 1970 Health and Education Report, the 1970 complaint, all the pleadings, motions, docket entries, zoning maps, and court orders. As the board knows, the school district has to file biannually compliance reports, and the school district has dutifully filed those compliance reports with the Honorable Court from 1972 to 2015, I guess 2016 now. We've also analyzed the TEA regulatory materials, school report cards, the quality of teacher surveys. We've analyzed TISD materials, board minutes going from 1972 to 2015. We've also taken a look at campus improvement reports, superintendent's annual reports. We've analyzed consultant reports. We reviewed and analyzed discovery and other materials related to the Department of Justice 2012 investigation. And we reviewed the Department of Justice letter of findings. And just as a point of reference, in that letter of findings, the Department of Justice did find facilities and extracurricular activities as being unitary. And as I understand, we were very close to transportation also being declared unitary. We've also conducted interviews of key TISD administrators as well. We've come also to the conclusion that the desegregation order pales in comparison to federal and state guidelines when it comes to the provision of equal educational opportunities to students and making sure that quality of education is done year in and year out. And that many of these rules, laws, regulations, edicts, orders, supervisory issues go well beyond any desegregation court order. And then finally, we have concluded that the school district, Tyler, has satisfied its burden and is eligible for unitary status. Good faith compliance with its desegregation orders for a reasonable period of time has occurred, and the vestiges of prior discrimination with respect to a prior dual school system have been extinguished to the extent practical. Thank you for being of service to the school district.
Thank you, Mr. Ronquillo. All right. Board members, at this time, going forward, we will have an open meeting on the 16th of May, 17th, 6 p.m. We will take this information. This is the first time we've had this presentation. We will take the information, the recommendations from our attorneys, and then we will have a time for public comment. We have one now if anybody wants to comment, but we didn't have any sign up, right? Nobody? Okay. So we will have another time on the 17th. We will have a similar presentation. It will have a time for public comment then as well. And then we will have probably, depending on how that meeting goes, we will have another meeting followed shortly thereafter in which this will be on the agenda as well. So if anybody has any questions, feel free to contact your board member or Dr. Crawford's office, and we will work our way through this process. Any comments from board members? Okay, and any questions you have for the attorney, probably go through Dr. Crawford and we will get that answered as well.
Yes, sir, Mr. President, real quick, we will have this presentation posted on our website, on the front page of our website. We'll also have a recording link to this meeting tonight, this the first time that this has been presented in an open meeting, this information. Actually posted on our website as well. So there will be resources there. We'll make sure that the publication of next Tuesday's meeting at 6 p.m. will be appropriate as well. So I just want to make sure that they will have some resources to access via our website in regard to this presentation tonight, along with the actual video recording.
Thank you, Dr. Crawford. Any other questions, comments? All right. If not, that's all we have. There's no action tonight, so I'll entertain a motion to adjourn.
So moved.
Thank you, Mr. Washman. Second?
Second.
All right. All in favor say aye.
Aye.
Opposed? All right. Thank you for coming. We are adjourned.